Well, good evening, everybody. I think we have now admitted, as they say, most people to this evening's lecture. And I'd like to welcome everybody to our fourth annual Baroness Butler-Sloss Family Law Lecture, hosted here by us at the University of Exeter, albeit unfortunately online. So I think most of you would know me, but my name is Professor Anne Barlow, and I'm Professor of Family Law and Policy here at Exeter. I also lead the GW4 Family Regulation and Society Network, in which colleagues from the Universities of Exeter, Bristol, Cardiff and Bath collaborate on research ideas around family law and policy. And so our network co-hosts this event, and I have somewhere put in the chat our network website in case you're interested in the sort of research that we do more widely. However, before moving on to our formal introductions of our speaker and then to Baroness Butler-Sloss, who lends, of course, her name to this lecture, may I, as this evening's chair, remind everyone of a few online housekeeping matters. First of all, the online etiquette of using appropriate language will be posted in the chat. I think everybody is muted for this lecture. But if you have questions for our speaker, who has kindly agreed to take questions at the end of her lecture, please do post them in the chat and they will be sent directly to me, and I will put them to her at the end of the lecture. So we're very much looking forward to the lecture, which is this year to be given by Gillian Douglas, who's Professor Emerita at King's College London, and someone, as you will hear, who has been at the forefront of family law debates throughout her academic career. We're therefore very much looking forward to hearing her reflections on the subject of achieving family law reform, evolution versus revolution this evening, which I'm sure is a subject dear to the hearts of many of us. So I will now hand over to my colleague, Professor Mark Goodwin, who's our Deputy Vice-Chancellor for Global Engagement at Exeter, to begin the formal introductions to this evening's event. Thank you very much, Mark.
Thank you, Anne, and it gives me great pleasure on behalf of the University of Exeter to welcome you all this evening to what I'm sure will be a really exciting and stimulating lecture. We're very pleased that this annual event continues to be one of the highlights of the law school calendar, and that family law at Exeter continues to go from strength to strength. By way of background, the annual lecture combines both Exeter's Butler-Sloss Family Law Student Lecture, given in honour of Baroness Butler-Sloss each year, with the annual lecture of the GW4 Family Regulation and Society Research Network. And as Anne has explained, this network is a grouping of family law and policy academics from Exeter, Bristol, Cardiff and Bath, who undertake collaborative research aimed at informing family law and justice reform. And we're very pleased to welcome our GW4 colleagues and students, who I understand have already today participated in a family law workshop on the theme of researching family law in a changing world. And this also means that we're particularly delighted that this year's lecture is to be delivered by a most eminent member of the academic family law community, Professor Gillian Douglas. This is not only because Gillian's own research has spanned almost every aspect of family law over the years, but also because she was a founder member of the GW4 Research Network when, back in 2010, she was at Cardiff Law School. Professor Douglas is now Professor Emerita at King's College London. Her work will, of course, be very well known to this audience of academics, students, practitioners, judges, and policymakers. And this evening, we are all very much looking forward to her insights into her subject of achieving family law reform, evolution versus revolution, a topic which is particularly important on the eve of the introduction of a new era of no-fault divorce, only some 30 years after this was recommended by the Law Commission of England and Wales. We're also very fortunate that our speaker is to be formally introduced to us in a moment by another most eminent family lawyer, the Right Honourable the Baroness Butler-Sloss, GBE. Baroness Butler-Sloss became the first woman Justice of Appeal in 1988, and in 1999 she was appointed as the President of the Family Division, making her the highest ranking female judge in the UK at that time. She chaired the Cleveland Child Abuse Inquiry, which led to the Children Act 1989, and has given many leading judgments on family law issues. We are very honoured to also say that she is a particular friend to the law school at Exeter. Not only has she often given her time to speak to our students about family law subjects, but she was a strong supporter of our colleague, Professor Liz Trinder's groundbreaking research on divorce law, which in turn was critical in shaping the new divorce law. So let me now begin the introduction of tonight's speaker. Professor Douglas was Executive Dean of the Dixon Poon School of Law at King's before her recent retirement, having previously taught at the universities of Bristol and Cardiff. She is a Fellow of the British Academy, the Academy of Social Sciences, and the Learned Society of Wales, and is an honorary bencher of Gray's Inn. She is co-author of the leading textbook, Bromley's Family Law, and her highly acclaimed most recent monograph, Obligation and Commitment in Family Law, was published in 2018. She was until recently a case comments editor for Family Law and co-editor of the Child and Family Law Quarterly. She's also conducted several empirical studies focusing on the legal implications of relationship breakdown, and she is a co-investigator on the Fair Shares project led by Professor Emma Hitchens of the University of Bristol, which is examining the financial arrangements that couples make when they divorce. She's also currently chairing a working party formed by Justice, the UK section of the International Commission of Jurists, which promotes human rights and the rule of law, to consider how private family law proceedings can be improved to enhance access to justice for separating families. I'm sure we're all looking forward immensely to Professor Douglas's lecture, and I'll now hand over to Baroness Elizabeth Butler-Sloss to complete the formal introduction. Thank you.
Thank you very much, Professor Goodwin. It's a huge honor for me to have this lecture in my name, and I thank the university. I really don't feel that I'm worthy of it, and it's a huge pleasure for me also to be involved from time to time with Exeter University, who gave me an honorary degree many, many years ago. I am particularly interested also in the huge work done by Professor Liz Trinder on no-fault divorce, which was absolutely the basis of what we managed to achieve eventually in the Divorce Act. I only hope that it will work out to be as good as the work that was done by Exeter University in particular. I'm very impressed also with the work done by the group of universities, some of whom are watching this evening, and I wish them well in this enormously important job of trying to improve family law, which needs it in all sorts of ways. But can I now come to the important part of this evening and say that we've had two extremely distinguished speakers speaking under my lecture name. And it's a huge pleasure and a privilege for me to be introducing the third really important and distinguished person who is to give our lecture today. You've heard from Professor Goodwin a short CV of Professor Douglas, so there's no need for that, except I'm delighted that she has been so involved with Bristol University, which I was involved with at one time, and also with King's College London, which I was very much involved with. It's a huge pleasure that she's taken the trouble to come and speak to us all this evening. And may I now turn over to her to give us her lecture.
Thank you very much. Well, thank you, Baroness Butler-Sloss, for your very kind introduction, and to Professor Mark Goodwin. It is lovely to be back with friends and colleagues in the network. I only wish it could have been in person, but it's a thrill to be with you, and a particular honour to be giving this Baroness Butler-Sloss annual family law lecture together with the GW4 network lecture, and a real privilege to have been introduced by Baroness Butler-Sloss herself. When Professor Anne Barlow issued the invitation to me, she suggested I might look at family law reform, and she asked the question, why is it that it can seem so difficult to achieve at times? And it was a great idea, and I've really enjoyed reflecting on this question. So I'm going to begin by setting the scene with some well-known cases that demonstrated that reform was called for, but which prompted quite different responses. And you will, I am sure, all be very familiar with each of these cases. My first case is Burns and Burns. In 1981, Valerie Burns, who was known as Mrs. Burns, although she wasn't married, brought an action for a declaration that she had an interest in the home she'd shared with her former partner, Patrick Burns, which he held in his sole name. Her claim failed, both at first instance and on appeal. Despite living with Patrick for 19 years, having 2 children with him, contributing to the household expenses through part-time earnings, and the fact that they'd held themselves out as a married couple, she failed because she couldn't establish that she'd contributed financially to the acquisition of the home. The courts held that there was therefore no resulting trust in her favour. At that time, her claim was brought as a resulting rather than constructive trust, and she failed. And Lord Justice May commented, when one compares this ultimate result with what it would have been had she been married to the respondent and taken appropriate steps under the Matrimonial Causes Act, I think that she can justifiably say that fate has not been kind to her. Now, despite the cogent critiques of some, including Professor Rebecca Probert, that this case, featuring as it does a breadwinner-housewife relationship, no longer represents the norm for either married or cohabiting couples, Mrs. Burns's case has nonetheless been held up ever since as a paradigm example, both of why it pays financially for the more vulnerable partner in a relationship to be married, and also why the law governing cohabitation relationship breakdown needs to be reformed. But despite some tweaking of the case law over the years, most notably by the House of Lords in Stack and Dowden and the Supreme Court in Jones and Kernott, the law has remained largely stuck. The Law Commission's review, published in 2007, which proposed a discretionary remedial jurisdiction to deal with these kinds of cases, was not taken forward by government. So 40 years on, since Valerie Burns failed in her claim, we're still without a law that can meet the justice of such cases. And we now await the deliberations of the House of Commons Women and Equalities Committee to see if reform can finally be achieved. Now, my second case will be even better known perhaps to this audience and to the general public. It received extensive publicity in the media. Teenie Owens petitioned for divorce in 2015, her petition relying on her husband Hugh's behaviour. Most unusually for divorce proceedings, Hugh defended the case, and His Honour Judge Tolson QC, finding that at best the allegations relied on by Mrs. Owens were flimsy, dismissed her petition. Neither the Court of Appeal nor the Supreme Court could find any error in how Judge Tolson had applied the law. As Sir James Mumby noted, Parliament has decreed that it's not a ground for divorce that you find yourself in a wretchedly unhappy marriage, though some people may say it should be. And in a very powerful judgment, he highlighted the hypocrisy and lack of intellectual honesty, which is so characteristic, as he said, of the current law and procedure of divorce. And his reference to the charade of modern behaviour petitions was robustly confirmed by the careful, comprehensive findings of Professor Liz Trinder in her Finding Fault study, to which Baroness Butler-Sloss has referred. Now, the Owens case, plus Liz's research, together with continued lobbying by the professional organisations such as Resolution, and the efforts of Baroness Butler-Sloss herself in the House of Lords, finally prompted the reform abolishing fault-based divorce, first advocated 30 years ago, and which will come into effect, as we know, next month. Now, Burns and Owens both demonstrated the need for legal reform. This was achieved in the one case, but not the other. And both also showed how long it can take to achieve change. However, neither of them set out to prompt a change in the law through their litigation. By contrast, the case brought by Rebecca Steinfeld and Charles Keedon produced meaningful change very quickly. And their case can be seen as the strategic use of legal proceedings to help achieve reform of the law. Mrs. Justice Andrews summarised the facts of the case in her first instance judgment. The claimants, she said, are a young couple in a committed long-term relationship who now have a child. They wish to formalise their relationship, but they have deep-rooted and genuine ideological objections to the institution of marriage. They wish instead to enter into a civil partnership, a status which they consider reflects their values and gives due recognition to the equality of their relationship. However, they're currently unable to do so. Now, we know that they brought judicial review proceedings against the government, arguing that the introduction of the Marriage Same-Sex Couples Act 2013, by offering the choice of whether to marry or form a civil partnership only to same-sex couples, had rendered the Civil Partnership Act 2004 incompatible with Article 14 of the European Convention on Human Rights when read in conjunction with Article 8. And they succeeded in obtaining a declaration of incompatibility in the Supreme Court in 2018. And the law was changed through the passage of a private member's bill sponsored by Tim Lawton MP in 2019. So in contrast to the 30 years it took to achieve divorce reform of a law dating back to the 1960s, in a mere 5 years from the enactment of the Marriage Same-Sex Couples Act, the highest court in the UK had found the law to be incompatible with the European Convention, and in 6 years it had been amended. And this came on top of the apparently lightning speed with which the position of same-sex couples had itself been assimilated to that of heterosexual couples. So family law reform of the most fundamental kind, subverting the traditional understanding of marriage, was achieved in this jurisdiction in less than 2 decades. Such a shift in the law certainly looks revolutionary. By contrast, we still marry according to rules, the origins of which can be traced back to at least 1836, a position which the Law Commission are currently examining with the expert assistance of Professor Rebecca Probert. So how can this state of affairs be explained? Well, let me explore first what I think is meant by family law reform. The dictionary definition of reform is improvement or the correction of errors. Law reform is a term used to focus on improving the operation or impact of the law. The emphasis is on making law as a medium of policy and an instrument of governance work better and thereby improve conditions in society in some way. But not all changes to the law are regarded as law reform. So what specifically do we mean by this term? Well, we should be able to answer this question because we do, after all, have an independent body expressly set up to bring about law reform, the Law Commission of England and Wales, established together with the Scottish Law Commission by the Law Commissions Act 1965. And Section 3, subsection 1 provides that it's the duty of these two commissions to take and keep under review all the law with a view to its systematic development and reform, including in particular codification of such law, elimination of anomalies, the repeal of obsolete and unnecessary enactments, reduction of the number of separate enactments, and generally the simplification and modernization of the law. Now, this appears to focus very much on tidying up the law, a technical legal exercise requiring the expertise of skilled lawyers. In introducing the Law Commission's bill in the House of Lords, Lord Gardiner, who was then the Lord Chancellor, illustrated this point in a way which I think is pleasingly relevant to the issues the Law Commission are currently dealing with. He used the law of marriage. He related how, back during the post-war Attlee government of 1945 to 51, he'd then drawn attention to the need for a systematic process of law reform. And he'd asked, where is our law on getting married contained? And the answer that was given to him at that time was that it was contained in no fewer than 40 Acts of Parliament. And he then proceeded to read out the titles of each of these 40 acts in the debate. Don't worry, I'm not going to do that, but suffice to say that he began with the Marriages, Contracts and Consanguinity Act 1540, and he ended with the Matrimonial Causes War Marriages Act 1944. The Marriage Act 1949 was in fact the first consolidating measure to be passed under the Consolidation of Enactments Procedure Act 1949, which was designed to deal with this kind of legislative complexity. So it's ironic then that what looked like a wonderful rationalisation back in 1949 is now itself the subject of detailed and long overdue Law Commission scrutiny. Now, in reflecting on law reform from an American perspective around the same time, the eminent legal historian Professor Lawrence Freedman also considered reform as a largely technical exercise. Both in the mouths of laymen and lawyers, law reform hasn't necessarily stood for so grand a programme as the word reform may seem to promise. Throughout most of its range of meaning, it's referred to what one might call, for now, lawyer's law, matters of primary concern to the legal profession. And he said, in law as in politics, reform is not revolution, and no torchlight parades ever demanded the union of law and equity. So law reform might be seen as kind of Benthamite project to rationalise, update and simplify the law, turning it from the morass of case law or the confusion of the statute book's accretions over time to the elegant clarity of codifying legislation. But for Lord Gardiner, it wasn't just a question of tidying up the law. He went on to tell the House of Lords, law is not a matter only of interest to lawyers. It concerns every citizen in most of the daily aspects of his life. If our law needs reforming, it's above all in the interests of laymen that it should be reformed. And I hope you'll forgive the gendered language a day after International Women's Day. In providing a statute note on the Act in the Modern Law Review, Lord Chorley and Professor Gerald Dworkin also noted that, contrary to Freedman's view, lawyers' law is never just about matters of concern to lawyers. It's difficult to differentiate straight matters of law reform from policy considerations. Most areas of law have wider social and political content. Walking a fine line between political reform and lawyers' reform is a task the Law Commission has had to undertake ever since. Now, the Law Commission's website today tells us that they aim, first of all, to ensure that the law is as fair, modern, simple, and as cost-effective as possible. And the word fair is crucial. A law that fails to meet or no longer meets the needs of those living under it produces unfair results. And reforming it is a matter of justice, not just efficiency. We expect that by changing the law or its working, we'll not just make things simpler for the lawyers administering it or the students learning it, but better for the people whose lives are affected by it. So let me move on then to consider the conditions that might be necessary to bring about reform. The identification of a problem is the first step. And the problem has to be seen as a legal problem. In other words, the law has to be found wanting, either by working poorly or failing to tackle an issue appropriately, so that the solution to the problem lies with amending the law itself. So to take two current examples, weddings law and divorce law have been seen as in need of reform because they no longer reflect public attitudes or behaviour. In the former case, the law is seen as not giving couples enough say in how a wedding that they wish to be legally recognised should be celebrated. In the case of divorce, the Finding Fault study and the Owens case highlighted the hypocrisy and uncertainty of having to prove one of the fault facts for irretrievable breakdown. And as Sir James Mumby quoted in his judgment, these problems are hardly new. They date back at least to 1906 in the case Dodd and Dodd. But by contrast, problems can manifest themselves through the legal process, but they won't be resolved through a change to the law. Take, for example, what's been described as the enduring, well-known scandal by Lord Stevens in Re T of the disgraceful and utterly shaming lack of proper provision for children who require approved secure accommodation. This issue has just been considered by the Nuffield Family Justice Observatory in an evidence review relating to children deprived of their liberty. The dearth of appropriate registered accommodation leaves the courts being asked by local authorities to authorise through the inherent jurisdiction the holding of children in unregistered places. In Re T, the Supreme Court confirmed that such authorisation is lawful, but they expressed profound anxiety about this state of affairs. And in the words of Lady Black, they noted the fact that judges and others have been drawing attention to the dangerous inadequacy of this aspect of the childcare system for years, without any effective steps having been taken to solve the problem of resources for children with exceptional needs. So we have here an example of a problem which can't be remedied by law reform. It's a resources issue. Now, how you frame the problem or mischief can also determine the reform that you wish to produce. If we take the arguments used to create civil partnerships, to extend marriage to same-sex couples, and then to allow heterosexual couples to enter into civil partnerships too. In 2004, it was argued that the problem that same-sex couples faced was their lack of access to the same or similar rights and obligations as spouses. So creating a parallel institution for same-sex couples, civil partnership, which bestowed those same rights and obligations, was seen as giving same-sex couples equality with married couples. In 2013, however, the contention was that such formal equality wasn't the real point. Refusing same-sex couples the right to marry was discriminatory because they were excluded from achieving the same status as heterosexual couples. Civil partnership was a separate status. It marked same-sex couple partners as different. As Maria Miller MP put it, Parliament should value people equally in the law, and enabling same-sex couples to marry removes the current differentiation and distinction. And the same argument, based on discrimination, applied in extending the choice to marry or enter a civil partnership to heterosexual couples in 2019. The way a problem is perceived is also a matter of timing. Think again of the length of time it's taken to achieve divorce reform. In the 1990s, when the Law Commission proposed their reforms, the project was very much a Law Commission project. It was based on a clear legal understanding of the failings of the existing case law and practice. These failings, again, were demonstrated by solid research evidence, at that time by Gwyn Davis and Mervyn Murch of Bristol University in their book, Grounds for Divorce. But the removal of fault as the basis for proving irretrievable breakdown, much approved by family, lawyers, and academics who saw it as a more civilized way of ending a marriage, was simply spun by opponents as making divorce easier. I think that those promoting the reform were loath to say that it would in fact make divorce harder for many people by lengthening, significantly in many cases, the time taken to reach the final decree. Now, with no demand from the general public at that time for divorce reform, and no cause célèbre like the Owens case to stimulate such demand, the Conservative government lost its nerve and delayed implementation, and the new Labour government then scrapped the whole thing. So this raises the question of who identifies the problem and whose identification of it counts. As with the example of divorce reform, lawyers or other professionals may identify a problem in the working of the law, and we'd expect them to be alive to the difficulties arising for clients and to use their professional organisations' lobbying skills to seek improvements. Resolution, the Solicitors Family Law Association, for example, lobbied for many years to achieve no-fault divorce. Lawyers and financial advisors, as well as women's groups, were instrumental in highlighting the importance of pensions being taken into account as part of financial settlements on divorce, and in achieving the addition of pension attachment and pension sharing orders to the menu of orders in the Matrimonial Causes Act. The lawyers at the Law Commission too, of course, have identified problems that require attention. The most important of their projects in the family law sphere was the complete overhaul of child law, undertaken under the direction of Lady Hale, then Professor Brenda Hoggett, during the 1980s, and linking up with the law relating to public law, and very much influenced by the work of Baroness Butler-Sloss in the Cleveland inquiry. Now, the aims of the review of the Law Commission, which focused on private law, fitted in with the original focus of the Commission's work on modernisation and simplification. The Law Commission said that the ultimate aim of the review of child law was to bring together into a single comprehensive code the many concepts and procedures used in private law to allocate responsibility for children, and that on a technical level, they wished to rationalise and simplify a system which contains many gaps, inconsistencies, and unnecessary complexities. But they also made it clear that the goal was not just technical improvement. They said, we wish to ensure that the law itself accords as best it can with the first and paramount consideration of the welfare of the children involved. A simpler and more rational system must not be achieved at the expense of the very people whom it is or should be designed to serve. Now, the Law Commission's standard way of working is to produce an initial consultation paper setting out the problem they're investigating and making provisional recommendations or a range of suggestions for possible reform, and inviting comment on these in order to inform their final recommendations, as well as professional groups, individual practitioners, and lobby groups or individuals with direct experience and particular views on how the law needs to be reformed. Academics will often submit responses, And the membership of the Law Commission, of course, also includes academic lawyers. The Commission takes due account of academic research, sometimes appointing academic advisors, such as Professor Probert, sometimes commissioning research, although their funds have been very limited, and holding meetings and exchanges of information with researchers actively working on a topic so that they can take findings into due consideration. So this is an apposite point, say a little bit more about the role of researchers in the law reform process, because it may not be so apparent to students and practitioners, but most academics seek to undertake research and scholarship that can enlighten those using the law, as well as those learning it, on its effects and implications. Most will hope that their arguments, their findings and conclusions can help either make the law work better or make the case for it to be changed. However, I think it may be easier for academic work to point towards what's wrong with current law rather than what it ought to be in the future. And this, I think, is because the nature of policy is that there'll usually be a range of options for how to improve a situation rather than a simple yes/no to a particular policy prescription. I think the continuing struggle to achieve cohabitation law reform is perhaps one of the strongest examples of this. The findings of Professor Anne Barlow and other researchers have been relied on by many of those advocating reform of the legal position of cohabitants, including Lord Marks in promoting his cohabitation rights bill in the House of Lords, and Tim Lawton MP in bringing forward the Civil Partnerships, Marriages and Deaths Registration Act 2019, which dealt with the Steinfeld and Keedon issue. But their two legislative schemes are radically different in approach. The one proposes an opt-out discretionary regime for separating cohabitants. The other enables cohabitants to opt in to civil partnership and all of the law that applies to that status. So the point is that while research can help strengthen the case for the importance of law reform, it doesn't necessarily tell us what reform should look like, at least not in any detail. And nor can it, I think, by itself transform the climate of public opinion so that reform becomes an inevitability. Academics and legal professionals also run the risk that their advocacy reform may be viewed as elitist or self-interested, pushing reforms when there's no real demand for them, purporting to know better than the general public what's good for them. We're all familiar with the distrust of experts expressed by certain politicians. So it helps if one can point to public pressure for reform. And both lobby groups and the media can be very instrumental in this regard. Let's take the fathers' rights movement in this country. It fought a highly effective campaign against the Child Support Act 1991, resulting in a multitude of changes to the original scheme. These changes began with a tactical withdrawal and eventually became an all-out retreat by successive governments. And in thinking of the time span for reform, it's worth noting that they achieved statutory change within 2 years of the Child Support Act coming into force in 1993. The Child Support Act 1995 introduced what are now known as variations to permit a degree of discretion outside the child support formula. And of course, they achieved fundamental change to the whole rationale of the scheme by 2008 in the Child Maintenance and Other Payments Act of that year. That turned child support into a last resort rather than the first port of call for parents seeking child maintenance. Now, flush with this success, the fathers' rights groups also sought to address what they wrongly perceived as bias against them in the family courts. As we know, their campaign resulted first in the introduction of activity directions and conditions to monitor and enforce what are now known as child arrangements orders, and the insertion of the presumption of parental involvement into the welfare principle in Section 1 of the Children Act by the Children and Families Act 2014. And while divorce reform after 1967 wasn't particularly the target of public lobby groups as it had been in earlier decades, it could be said that the print media fulfilled this role in their adoption of the Owens case as part of their campaigning activity. The Times newspaper was running a family matters campaign looking at various aspects of family law, including calling for no-fault divorce, and the Owens case was a godsend to them. And the Daily Mail similarly called for reform, describing Teenie Owens as a wife in a loveless marriage, condemned to stay unhappily married because of the law. I think that press campaigning was part of the context in which the government brought forward reform, this time, of course, without bothering the Law Commission. So that shows that recognition of a problem isn't enough. There must also be acceptance of the case for reform on the part of lawmakers. Now, I think that most family law reform isn't party political. Parties on both sides of the Houses of Parliament have supported and promoted the major reforms achieved over the years, including in relation to divorce, domestic abuse, parentage through assisted reproduction, child law, and adoption. And we only have to think of Baroness Butler-Sloss, a crossbench peer, of course, bringing forward the Divorce, Etc. Law Review Bill in 2018 to help steer the Lord Chancellor towards divorce reform. Her bill didn't need to make progress through the Lords because faced with all of the context that I've described, the government pretty quickly committed to bringing forward its own legislation enacted in 2020. But it doesn't follow, therefore, that there's no political opposition to proposed measures of family law reform, nor concerted efforts to thwart them in Parliament. We all know that there were numerous efforts to scupper the introduction of civil partnership. If we go back earlier, there were moves to prevent single women or gay couples having access to assisted reproduction treatment. And we have the continuing frustration of the move to extend legal protections to cohabitants. And we can also remember how the provisions of what became Part 2 of the Family Law Act 1996 grew steadily more complex and obstructive as amendments put forward by those fundamentally opposed to making divorce easier were introduced. All governments have to undertake a political calculation to determine whether promoting or supporting a reform measure will be popular, neutral, or unpopular. They have to decide if it's worth spending political capital and devoting civil servants' time and effort to putting together reforms. So once again, we can see that timing is everything. Commit to change too early before public opinion is ready or public behaviour has changed, and reform may not make it or may fail. And Lawrence Freedman argued back in the 1960s, sometimes what appears on the formal historical record as a real moving and shaking is actually what might be called a hidden ratification. Formal legal change often comes at the middle point in a social process which requires a number of distinct steps for its completion. Formal legal change ratifies those steps already taken. So this leads on to the question of how one can evaluate the success or failure of law reforms. Ultimately, we want to ask whether they advance justice and fairness, but how do we assess this in practical terms? We might postulate that apparently revolutionary reforms may be less likely to succeed than those that look more like Freedman's ratifications, since they seem to disrupt rather than consolidate existing social processes of change. But this doesn't seem to be the case. For example, where reform has a clear objective, achieving it must surely signify its success. If we take extending marriage to same-sex couples, the 2013 Act has achieved its goal. Couples who couldn't formally marry can now do so. It's true they may be prevented from marrying through various forms of religious ceremony. That's not a failure of the legislation. So perhaps the narrower the objective, the easier to achieve it. Where reform has multiple or diffuse objectives, it may be harder for it to score well. Now, we proclaim the Children Act 1989 as successful in many respects, but the attempt of the Law Commission to do away with the win-lose approach by parents in private law disputes hasn't been successful. The Act provides that parents don't lose their parental responsibility and rights after divorce, even if not awarded primary care of the child. It changed the terminology used in these cases from custody and access to residence and contact. And when this failed to change attitudes, the 2014 legislation introduced the concept of child arrangements orders instead. But parents continue to fight bitterly over child arrangements. This is an example of the law attempting to lead change in social attitudes and beliefs, but not yet having had the desired effect. Now, this might be partly due to a failure to get messages across, but it's surely also because parents aren't ready for such change. And this is because it's not something that can be achieved solely through law or law reform. Shelley Day Sclater wrote convincingly over 20 years ago that parental conflict is crucially linked to the emotional trauma of relationship breakdown. It can't be wished or magicked away by the family justice system or wider society declining to acknowledge this. Okay, so what else might be a sign of success? What about longevity? We might think that if legislation has stood the test of time, that's a sign of success. Let's compare the Child Support Act, which, as I've mentioned, has been amended several times, both by primary legislation and frequent changes to the fiendish secondary legislation which underpins it. Needing repeatedly to tweak legislation suggests that there was something wrong, either with the way it was drafted or more fundamentally with the policy it was meant to implement. Or as with this example of child support, perhaps both. But just because a piece of legislation remains in existence for a long time, it doesn't follow that it's been or continues to be successful. As Rebecca Probert has said, in the context of weddings law after 1949, although there's been quite a lot of change to very specific issues, such as how places of worship can be registered for marriages, the lack of more wide-ranging reform shouldn't be seen as evidence of contentment with the status quo. And our discussion of divorce law reforms already shown how longevity is not necessarily a sign of health. So linked to this point, we might think that if a law is implemented smoothly and doesn't require several highest court determinations as to its ambit and effect, we could say it's successful. But many statutory provisions do require initial, sometimes repeated working through to test their meaning. Take, for example, the case law generated in interpreting the threshold criteria set out in just one subsection, section 31(2) of the Children Act 1989, to govern taking children into care. And within that mass of case law, think of the particular point concerning the standard of proof required to establish that a child is likely to suffer significant harm. It took multiple judgments from the Court of Appeal, the House of Lords, and the Supreme Court spread over more than a decade to settle this matter. So perhaps ultimately the most pragmatic criterion of success that we can apply is that there's limited complaint about the working of the reform. The Children Act was rightly regarded as a very successful reform, placing welfare at the heart of decision-making about children until the Fathers' Rights Lobby moved on from the Child Support Campaign to focus on residence and contact disputes. And no one worried too much about divorce law until it became an affront to common sense and public sentiment. If there's no complaint, there's no problem to resolve. And this then takes us back to considering the catalysts for reform and the need to conceive of an issue as a problem requiring resolution. Perhaps the best way of understanding this is that family law undergoes a cycle of development, consolidation, and ultimate rejection as it falls out of sync with behaviour and attitudes, and a fresh call for reform is made. Unlike evolution, however, there's a limit to how far law can adapt to its environment by itself without requiring a major reappraisal and overhaul. So is that when revolution occurs? Well, it's true, as I've said, that some reforms certainly look revolutionary. Take the enactment of same-sex marriage in 2013. It certainly looks like a revolutionary change, a decisive break with the past. But the 2013 Act was, of course, preceded by the Civil Partnership Act, 2004, which itself was preceded by the Adoption and Children Act, 2002, which opened up adoption to same-sex couples. And as the late and much missed Stephen Cretney traced in his Clarendon lectures on this topic in 2006, the whole matter of ending discrimination against same-sex relationships took from the 1950s to achieve, from the Wolfenden report recommending decriminalisation of homosexual acts through to equalisation of the age of consent in 2000, and then, as I've outlined, the further reforms moving up to 2013. Moreover, a change that appears revolutionary may quickly become mundane and eventually restrictive and conservative. The original civil partnership model enacted in 2004 didn't meet what people wanted, falling short of same-sex marriage and then failing to offer a heterosexual alternative to marriage itself. The Gender Recognition Act, passed in the same year, is another example of what looked like revolutionary change, which has since perhaps fallen out of sync with attitudes towards sex and identity. And finally, even revolutionary changes, such as these might seem, can be seen as seeking to reassert the centrality of the nuclear family model. We don't have recognition of polyamorous relationships. We don't have more than 2 legal parents of a child at a time. Changes to the law on divorce and civil partnership or same-sex marriage have all been justified as enabling cohabitants to marry and therefore add to the stability of relationships. And we haven't broken away from the conjugal model of relationships to ones based on caring, as many scholars, such as Professor Jonathan Herring, have advocated. Sometimes attempted reforms don't completely succeed and have to be revisited. The Civil Partnership Act is an example. And sometimes attempts at reform are misguided. The Child Support Act, for example. Sometimes we just have to wait a very long time indeed for reform to take place at all, like with cohabitation. As family practices, behaviour, attitudes and structures change, I think it's safe to conclude that law is almost always in catch-up or ratification mode, at least in a democracy. Now that limits the opportunity to attempt true revolution and the fundamental disruption of prevailing norms, and it points towards achieving change through an evolutionary process. But it also means, or should mean, that there can be adequate time and care taken to ensure that the reforms that are put in place are designed to deliver not only more up-to-date, simpler and more comprehensible laws, but fairer outcomes for all family members. As the late Dr. Martin Luther King said, the moral arc of the universe is long, but it bends towards justice. That's a noble sentiment for lawyers, students, academics, and policymakers to keep in mind as they contemplate the enduring task of family law reform, be it through evolutionary or apparently revolutionary means. Thank you.
Thank you, Gillian. That was absolutely brilliant. I think everybody would have enjoyed that very stimulating walk through your reflections on how we sometimes strike a confluence of everything that needs to go forward in order to make law reform possible, and how sometimes other things which you've pointed to just make it impossible, despite the research, despite perhaps the pressure group campaign. It's a really interesting way of looking at this. So I'd like to thank you on behalf of everybody. I'm sure we could clap you aloud if we like, or in the now common online way. But we all very much enjoyed that, I'm sure. So we can move now, thank you very much, to questions, and thank you again for agreeing to take questions. At the moment, I'm waiting for some more questions to come in. I have a few. So just to remind everybody that if you want to put a question to Gillian, you can send me a direct message on the chat. Just look for my name, Anne Barlow, and send a question, and I will read them out as best I can and group them as necessary for Gillian. So as was mentioned earlier, we did have a student workshop, which has also become a regular feature of our research network each year, where some of the students were putting questions forward for you this evening, if that became a good question to ask. And I think one, it's perhaps the biggest question you could possibly ask, but they have at least time limited it. But we were asked, what do you think the biggest challenge for family law will be in the next 5 years? So I don't know if you want to have a think about that for a moment, but we were speculating amongst ourselves what that might be, but I'm sure you've got some ideas yourself. So if we perhaps start with that one,
okay,
or move to an easier question if you like.
Well, I thought I might be asked what I thought needed reform, whether it's the biggest challenge, and whether it's, at least you've limited me to 5 years. If you'd said 50, I think I'd have struggled. I mean, I do think that cohabitation law reform has to be dealt with. And I really am pinning a lot of hope on the Women and Equalities Committee. I do think social attitudes have changed quite a lot in the past decade or so, and that maybe politicians, if there is the headspace, of course, to do anything at all in the next 5 years, will finally get to grips with it. Quite what that reform should be, well, as I'm an academic, I can only point to what's wrong. I don't know what the prescription ought to be, although I have my own thoughts. I mean, I suppose the other area, we all know that we live in an aging society. We all know that the ties across the generations are important, and that the tie upwards as well as downwards, as it were, up to your own parents as well as down to your children, are incredibly important, and sort of the pandemic, I think, has reinforced the feeling that we don't deal with those who need care in nearly a good enough way. However, I don't think that I'm not sure that family law can provide the answers to that. I don't think family law particularly has the tools to deal with that. I don't suppose that we would seriously consider the kind of regimes that do exist in some jurisdictions to impose a maintenance obligation to support parents. I just can't see that in this society, and I don't suppose it will be any more effective than our current rather woeful regime for dealing with child maintenance. So I just don't think that care for that, it's not just the elderly, of course, it's people with all kinds of needs. I'm not sure that family law has the tools to deal with that problem. So it comes back, I think, to issues surrounding cohabitation. As you know, I as you mentioned, I chair the Justice Working Party looking at private law proceedings. There, I think we're looking at changes not to the substantive law as set out in the Children Act, but the actual procedures and mechanisms available to help parents deal with disputes over their children. And that clearly does need work. The work that you and Rosemary Hunter and Adrian Barnett did on the harm report for the Ministry of Justice, of course, set out an incredibly challenging agenda for the family justice system to cope with these issues, and we have to see where that goes, and I hope that the Justice Working Party will be able to add to the impetus for reform on that issue, but that wouldn't be a substantive law change.
But a very important one nonetheless, of course. Right, so the questions are rolling in now. So first of all, what do you think the effect of the new Divorce and Dissolution Act reform will be? Do you think it will work as intended, or what are the unintended consequences possibly?
Well, I have seen some comments by practitioners who are worried that the constrained timescale for obtaining a divorce may lead to people making inadequate financial arrangements. I don't know, because, as you know, the study that Emma Hitchings and I are doing at the moment, which is looking at financial arrangements, we don't know the outcome of that yet. So we don't know, we've got nothing to compare, really. I can't see why the system shouldn't work. I think it will take a while, obviously, to settle down so that the practitioners are familiar with it and know how to advise clients. Maybe more clients more litigants will deal with the process themselves. And that does create a concern if they're not getting adequate legal advice around their own divorce. But I just think it's an unalloyed blessing that we will be moving away from the regime that we've had since 1970. It's 50 years. It's time to move on, and I do think that there is no reason why it should have any particular problems. I don't see why it would have any impact on people rushing into divorce. I don't think people think like that. I think it'll be fairly neutral, but better.
Well, let's hope. That's very optimistic, and there are always unintended consequences. I suppose we're all just trying to speculate what they might be, but definitely it's a law that's long overdue and in many ways bound to bring improvement in the process. So I have a question. I'm sorry, I can't always read people's names that are posing them, but picking up on your point about fathers' rights groups, you're asked, do you still consider that reform when they bring pressure to bear to change the law, if they only reflect one particular interest group rather than an overall societal sentiment that reform is needed?
I think that's a very good question. It goes to my point that for me, law reform should be about justice. Now, one could say on one level that the presumption of parental involvement, has it had any impact at all? Pretty limited anyway. So maybe it hasn't done any damage. I don't know.
I mean, I think it's quite interesting because they certainly in out-of-court settlements, we were picking up that perhaps it had quite an impact in the way people decided to share care. But
that might not necessarily be a bad thing.
No, absolutely not. But it's shifted, I suppose.
But I think the more
norm.
The profound point in the question is that can you have justice when it is particularly, when the reform so-called is particularly pushing a certain line, I suppose, I mean, if there were robust evidence that this were damaging, then it would certainly not count as a reform. But when I was sketching out this lecture, as you know, Anne, I told you I had a lot more material than I could use for the time. And I was pondering, why is it that the Child Support Act, for example, a lot of women, a lot of mothers complained very hard about the failings of the Child Support Act from their perspective, the non-payment of maintenance, which is still very, very widespread. Why is it that women's complaints are not given the same weight as men's? Well, I think we can speculate on the answer, or perhaps we know the answer to that. But it did strike me that women have to work much harder to get their interests across, and maybe Parliament, reflects wider society in that inequity, that inequality. But I think it's true, and so I think I concede the point that the questioner is making, that arguably I should be more critical or more careful in describing those changes as reforms, because they're not necessarily beneficial.
Thank you. That's a really interesting answer. Moving on to cohabitation reform then, you're asked, if we do achieve it, if the law does move on in that regard, will it reduce the importance of civil partnership or marriage in your view?
Well, I could throw the question back and say, what do we mean by important? Yeah. It seems to me that people now do marry or not marry, and they, we've never thought that they're carefully reading the textbooks, and well, we know that they don't, unfortunately, and that's why they get into so many difficulties, isn't it? I suppose you might say that the legal significance of marriage and civil partnership might be reduced if, as I think I would prefer, we simply assimilate cohabitants to spouses and have them subject to the same regimes and the same criteria as in the Matrimonial Causes Act. That would be my own preference. Now, maybe that would mean that fewer people would get married, but does it matter? People marry or civilly partner now for what the personal meaning that brings to their relationship and how they see their commitment to each other. I don't think it matters whether they marry or not, really.
Okay, thank you. So we've got quite a few questions now, and I'm just conscious of the time. So moving then to the next one is really talking about the problems that the family courts have in terms of the amount of time it takes to have any form of adjudication through that process. What do you think about privatisation of family law through arbitration? Is it a way forward, or solutions to few rather than the many, perhaps?
Look, it depends on the kind of dispute, I suppose. I think for couples who can afford it, dealing with their finances, it might be a very good way forward. I'm slightly more sceptical about child law disputes being settled in that way, mainly because I'm not sure yet that arbitration places the child and the child's voice at the centre of the process. And for me, the strength, or what ought to be the strength of the family justice system through the family courts, is that they should put the child and the child's perspective at the centre of decision making. Now, that doesn't necessarily happen in current family court cases because of pressure on FAcSS and so on. Nonetheless, I would be unhappy, I think, about arbitration as a process becoming a very common way of dealing with child issues, unless the process can in some way embrace the need to have the child in the room in some way. And I make the same point, I would say, in relation to mediation as well. I think that mediation, which is not child inclusive, is not delivering what we need for children in dealing with these disputes.
Absolutely, it's not, although I'm sure arbitrators will argue that children can be included in that process. There's certainly not, there's a focus rather than an inclusion in terms of the child's voice, from what I understand in that process. There's a point made, I think that may be Joe Miles actually, saying as a point of information on the upward support obligation of parents to elderly parents in particular. Jurisdictions also who do have that also have fixed inheritance rights as a sort of quid pro quo. So if we were to go down that route, there would be a shift of more than one law to get there. So I just throw that in as a point of information from Joe. Thank you, Joe. And a question now from David Tyzak. Do you think artificial intelligence is going to have an impact on family law in the next 5 years? So don't know if you have a crystal ball for that one.
I'm really not qualified to say. Yes, probably. But I simply don't know enough to begin to answer that question.
Thank you. Then we have one relating to human rights and how they, or that, I suppose that legislative backdrop provides an impetus for reform momentum. I can't always read who these questions are from. I think I won't guess, but do you think, or would you agree that surely the speed of reform in Steinfeld was arguably off the back of the declaration of incompatibility that was not a feature in Burns and Owens, because Steinfeld is a human rights case, so that the family law and policy underpinning civil partnerships wasn't really explored by the Supreme Court and didn't need to be? Do you think that's a fair comment? I think that might be from Andy Hayward, but I am guessing.
Yeah, I think that's a fair point. I mean, as I said, I mean, that litigation was brought to challenge the law. So it doesn't square with the other two cases that I referred to, of course, where they were just trying to get the remedies that they thought they were owed under the law. That case is an exceptional case, it's quite true. Nonetheless, it is striking, isn't it, that, and this is why when I was first thinking about the title for this lecture, which you pushed me to give you, fair enough, I did think, well, it seems so revolutionary. I mean, I remember, maybe I am very bad at gazing into a crystal ball, but I remember writing a piece in 2000 looking at marriage and cohabitation, and I didn't have civil partnership on my radar, not at all. I knew it was happening in other European jurisdictions, but it didn't cross my mind that it would be something that we would be implementing so swiftly. So I think the whole move in improving the position of same-sex couples is extraordinary, really. And Steinfeld and Keedon is part of that process. Nonetheless, of course, I argue that it does have its antecedents.
Absolutely. Then keeping, well, with cohabitation here, but a comment from Kate Cowdell, the Scottish Law Commissioner, with regard to cohabitation law reform, the introduction of legislation in Scotland, recommended by the Scottish Law Commission in 1992, took until 2006 and is now under review again by the Scottish Law Commission. So it's not a straightforward area to reform, she says, notwithstanding the numbers of cohabiting couples and obviously the changing attitudes. So I think we know that if we do get reform, it will have some teething troubles in that area, quite possibly.
I think it also maybe it slightly justifies the government making the excuse that they couldn't move forward with our Law Commission's recommendations in 2007 because they needed to see how the Scottish system was working. And lo and behold, the Scottish system is now undergoing reform. But of course, they've had the benefit of the 15 years or whatever of at least having some jurisdiction, which we haven't.
Well, it will be interesting to see whether we adopt a sort of completely different approach or sidestep the issue yet again until the brave Scots see how their further reform goes, but let's hope there will be movement. There's a question about online divorce proceedings. Do you think that will reduce the need for family lawyers or divorce lawyers in the coming years?
Well, not unless the online information and advice is very much improved. Maybe this is where AI comes in. You know, perhaps you can have a chat bot or something that you can talk to when you're trying to draft your petition. But no, I mean, I firmly believe that the withdrawal of legal aid was a disaster, particularly, you know, for family law. And that there is an immense need for reliable and professional legal advice and assistance. How it's delivered, the mode in which it's delivered, you know, by all means, we can have, you know, Zoom calls and so on and so forth. That's not the issue. But pretending that we can do without lawyers and legal advice is just not applicable at all, in my view.
And there was actually, I've just seen a further clarification of that question as to whether you have any particular opinions about the online divorce process, but I think you've probably answered that in the sense that...
Well, I mean, I don't actually, as a process in itself, I don't.
Okay, well, we have it, so we no doubt will refine it over time, as we always do. The next question is on financial resolution and the roles played by partners in the family. I think that the question says, do you think there is any scope for a double burden being taken into account by the courts where both partners are in full-time employment, while one partner is also carrying out the majority of the caring responsibilities, which is increasingly becoming the case for many families, but seems to be ignored in financial resolution. So the value of care in that sense.
Is it ignored?
Well, the questioner obviously thinks it is. But I suppose if both people are working, but one person is also doing all of the childcare, I mean, it's not considered a special contribution, for example, is it, to the family that you're doing both those roles, perhaps?
Okay, I mean, I think the Matrimonial Causes Act, Section 25, is broad enough to, even if it's not a special contribution, it should be broad enough to take account of the contributions and the losses and burdens that each party experiences during the marriage and at the end of the marriage. Now, if this is a question which might have in mind potential reform of the law to have a more sort of automatic 50-50, then I would certainly think that would be, of course, highly undesirable in my view. I am a very strong supporter of discretion. But again, I say that without having yet done the study, completed the study with Emma Hitchings, because I don't know how what looks like to me like very good flexibility actually operates in practice for the majority of couples. But in terms of a question of justice, yes, there ought to be a way in which additional burden is recognised. The only thing I would say about that, and I have written on the importance of sharing loss and burden fairly, but the only thing I would say is that realistically, most families don't have very much to share in terms of assets. And I think there is a limit to how perfect outcomes can be, simply because of the economic realities that face couples. But you shouldn't be at a disadvantage when you start in trying to negotiate an arrangement.
Right, well, I'm afraid, even though the questions are still rolling in, that we are out of time. And I think we have worked you incredibly hard, Gillian, and you have been terrific as ever in responding to the very challenging questions that some of the audience have been putting this evening. So thank you so much for doing that from me and from the network. And I'm going to hand over to our head of school here at Exeter, the head of the law school, of course, Professor Sue Prince, for the vote of thanks.
Thank you, Anne. Baroness Butler-Sloss, Professor Douglas, Professor Barlow, Professor Goodwin, colleagues, students, and other GW4 guests. Even though we are meeting remotely today, I wanted to thank you for being here in Exeter. It's a bit rainy, so it's not the best of evenings, I can tell you, but just so you can imagine it. And thank you for being at our virtual law school Baroness Butler-Sloss annual family law lecture. Thank you to everyone involved for enabling this lecture to happen today and bringing us all together to discuss such an important topic. This lecture series shows the huge importance that the law school places on family law. In the law school here at the University of Exeter, we are immensely proud of our research centre, the Network on Family Regulation and Society. The international and national impact of the work that's been done has been flagged already and mentioned by Professor Douglas in her lecture this evening. We have a team of prestigious family law researchers, and this is matched by the huge enthusiasm of our students for this area of law. Thank you, Professor Douglas, for an insightful and informative lecture. It's such a timely title, especially given the imminent introduction of the Divorce, Dissolution and Separation Act. I am pleased to hear how academic researchers can have such a huge influence and impact generally on policymakers and lawmakers and be a major factor and conduit for change in this area of law. So many of our audience today have personally impacted on law reform and the development of law and legal principle. And it's likely that as we emerge from COVID and changes that emerge from the introduction of technology, as has been raised by the questions today, that this will only continue. Thank you again for the presentation, and thank you to everyone for attending. And I very much hope that next year's annual lecture can be held in person at the University of Exeter. And I very much look forward to seeing you all there. Thank you again.
Yes, thank you, everybody. Thank you once again, Gillian.
Thank you. Bye.
Bye.